And many people got involved in the Windsor decision, okay? The ACLU was involved. The Senate was involved. But there was also opposition. There were amicus briefs on both sides. You know, this was one of the hot cases. So the National Organization for Marriage, which is against same-sex marriage, also wrote an amicus brief. Lambda wrote an amicus brief for Windsor. Okay, so that's basically the Windsor case. Now, who defends DOMA? The congressional Republicans defend DOMA, okay? Obama has said he does not defend DOMA, and the Department of Justice does not defend DOMA. Even though they are part, obviously, of the federal government, they don't defend it. Now, there was a lawsuit in the Republicans defending DOMA in these cases. There was a law firm that represented the congressional Republicans. And this gets into ethics of law firms. So now we're going to get into legal ethics. There was the law firm King and Spalding. And this created a controversy, so much so that many bar associations had forums on this. So King and Spalding initial decision was to represent the congressional Republicans in litigation concerning the Defense of Marriage Act, concerning DOMA. However, it was met with a campaign of criticism, and it was organized by LGBT groups and human rights campaigns, and even some of their clients objected. King and Spalding's a major firm. The controversy culminated in the firm's request to withdraw from representation and the resignation of a prominent partner. And this has fueled significant debate in the legal community about the propriety of criticizing a law firm for the choice of its clients, the extent to which law firm employees should ever be prohibited from advocacy that runs counter to the interests of a law firm client, and the potential conflict between a lawyer's ethical obligations and other values. So many questions arose out of the law firm getting involved here. And some of the questions that were addressed was, is advocacy aimed at encouraging a law firm to drop a client ever appropriate? What responsibility, if any, do members of the legal pressure have in the face of such pressure? This is important because each and every one of you may have these issues at some point. You may have an issue, even on a smaller basis, where your duty is to represent your client. That's one duty. But there's also the duty that to follow what's conscious, what's ethical, and what's public interest. And sometimes those two different obligations conflict. And what are you going to do? You know, it's similar, I don't want to say it's similar to fascism and what people in Germany had to decide, are they going to stand with the Nazis or not? But sometimes you're going to have to make decisions whether to drop a case, not take a case, because you don't find it ethical, or, like Clarence Darrow, to take up an unpopular cause, even though your firm may not like it and the community may not like it, but you believe it's in the interest of justice. That was the Evolution case, right? The Scopes trial, Clarence Darrow. I mean, it had enormous controversy. The churches were against it, but yet evolution now is very widely accepted. So these are the type of issues that come up in such controversial issues. Does the answer depend in part on whether the law being defended can be characterized as resting exclusively on historical animus, or whether it's a civil or criminal matter? Is this any different from the criticism leveled at lawyers for defending Guantanamo prisoners? So that's like the unpopular causes, but may have some justice. Police brutality cases. So the issue is, what are you going to do as a lawyer? Which causes are you going to champion? Which cases are you going to drop in these cases? How far can or should law firms go in prohibiting certain activities of its attorneys in deference to its clients' wishes? Should the withdrawal be viewed simply as a testament to an increasing societal commitment to equality, or instead as evidence that the legal profession's tradition of defending unpopular clients is increasingly under assault. So these are the other issues that arose in the legal profession from the Windsor case. The U.S. Supreme Court is now likelier to take on a case regarding DOMA due to the lack of agreement among the circuit courts. The Windsor case demonstrates the complications that exist with conflicting laws between states and the federal legislature. If a married same-sex couple travels to another state, their marriage rights may be reduced or eliminated depending on the laws of the particular state. So, we get into the issue of what's called portability. Even if a same-sex couple is legally married in one state, let's say Maine, okay? What happens if they travel outside the state? What if they travel to Utah? What if they get into a car accident and one of them is in the hospital? Can the other one visit as a spouse, extra visiting hours? This seems like a very little detail, but it's not. What happens if they are legally considered as married in Massachusetts and they travel to a state that does not recognize same-sex marriage and they have a child? And that child gets hurt and they cannot visit their child because they are not recognized as the parent. Or they move to another state and then there's a custody battle and they're not seen as a parent. They have no rights to the child. And the child has no rights to them as a parent, regardless of best interest standard. So, until there is a federal constitutional amendment or a federal law that recognizes same-sex marriage in every single state, same-sex couples, even if legally married in one state, are in jeopardy. Because as soon as they step outside that state, they may lose complete protection as a couple. Certainly if they move. This is a huge restriction. You have to advise people in your office, don't move. Or like someone called me yesterday, well, Thursday actually, and they said, okay, Sherri, we're legally married. I don't need to do the second parent adoption, right? Because second parent adoption is not easy. You have to spend money on a lawyer. You have to do a home study. I mean, it's a process. And they said, we don't have to do that anymore. I said, you know what? Because you may travel on vacation to another state that does not recognize same-sex marriage, that until the federal law makes it binding on all the states, and that could be a while, you're better off doing the second parent adoption. Now, some states may not even recognize the second parent adoption, but at least that gives you more protection. In the states that do recognize second parent adoption, but don't recognize same-sex marriage. So portability is an issue. If you are advising clients who are in same-sex marriages, just because they're legally married from Canada or the Netherlands or New York or Maine or Massachusetts or now Washington State, that doesn't mean that they have the full protections of a heterosexual couple. They certainly don't have the federal benefits until DOMA is repealed. And if they go to a state that is not recognizing their marriage, that does not give comity to the same-sex marriage, or in fact has a DOMA, a little mini DOMA, that they only recognize marriage between a man and a woman, or they don't even recognize a domestic partnership. Sometimes they'll treat the marriage as domestic partnership, give them partial right. But now they have to think about what state they're stepping into. They may have relatives in a different state. They have to think where they're stepping, because they may not get the rights as a spouse to their spouse or their child. That's a huge difference from a heterosexual couple. Okay? Even if the couple remains in the state where they were married, the couple remains excluded from federal benefits and protections available to other married couples. As we said, such as Social Security survivor benefits, the right to file joint tax returns, the right to take family leave, the right to petition for permanent residence for a foreign spouse, and the other benefits. And yet, both spouse resources may be counted as available resources when determining the availability of needs-based assistance, such as Medicaid. So what's interesting with many laws is that you're not entitled to the benefits that heterosexual couples get, but when it comes to denying you a benefit, your assets may be included together. So in Medicaid, even though the law may not permit same-sex marriage, if they're trying to determine how much assets you have, you would think, okay, so then this is good. If they don't recognize same-sex marriage, they'll only count half our assets. They won't count the other spouse's assets. No, in this case, they make the exception, and they count both partners' assets. If a couple marries in a state that permits same-sex marriage, but then later resides in a mini-DOMA state and seeks a divorce, the couple may face difficulty obtaining a divorce. The parties may no longer meet residency requirements of the state in which they were married, and the state of residence may not recognize the marriage and thus decline to grant the divorce. So this becomes a major problem, is that many people, for instance, got married in Massachusetts, and then they decided to move. And they moved to a state that does not recognize the same-sex marriage. Then they decide they want to get divorced. They can't get divorced in that state. There's no place for them to get divorced. How do they get divorced? So this becomes a major problem. How do they divide up assets? How do they divide up maintenance and alimony issues or even access with children if the state they're now in does not recognize divorce? So some states maybe will let them go back to the states to get divorced, but if you're not a resident anymore, many states will not let you go back even though you were legally married there. So then you have a problem getting a divorce. You have a problem dividing assets. You have a problem getting alimony. What happens if your spouse leaves you? If you're in a heterosexual couple, and if the moneyed spouse leaves you, you can get maintenance, alimony. You can get division of the assets, even if it's not in both names, even though it's not titled. But you worked on building these things together. You can get retirement benefits. What happens if you're married 20 years? If you move to a state that does not recognize same-sex marriage, you may not be able to get divorced. You may not be able to get alimony, maintenance, property division, retirement benefits, or attorney fees. Many states will grant the non-moneyed spouse in a divorce attorney fees. You may have a problem and not even get the attorney fees. So, divorce financial issues created by DOMA. Let's look at some of the financial issues. As I said, spousal maintenance may not be recognized. The gift tax will be owed by the donor. So normally you can transfer assets back and forth between spouses and it doesn't trigger what we call the gift tax. So the gift tax in America is that you can transfer up to $13,000 a year to someone who's not your spouse. After that, you get taxed. In addition, well, last year it was a $5 million exemption total, like your life exemption. But between spouses, you're not subject to gift tax. But with same-sex couples, because of DOMA, they are subject to gift taxes. So that means they can't transfer assets freely. They always have to think about that this is going to be a taxable event, even if they were together or married, for many years. What happens if one partner gets sick, one spouse gets sick? Okay? There are certain benefits that you're entitled to, disability benefits. But because of DOMA and it's not legally recognized, you may not get these benefits if you're in a same-sex marriage. Okay? Then you get into the issues of health insurance. Many states and the federal government, if you work for the federal government, it will permit you to give health insurance for your spouse. But if your marriage is not recognized, you do not get the health insurance, okay? You get into issues called COBRA. COBRA is that in case of divorce, you can utilize the health insurance of your spouse. Usually it's 18 months to 3 years, okay? But, again, because the federal government does not recognize same-sex marriages, you do not have a right to COBRA unless the health insurance plan of your company provides so. You know, many companies now will recognize same-sex marriage or domestic partnership. But what's very interesting that's happening, I'm getting this situation, is that let's say someone was in a legal domestic partnership and then the state adopts same-sex marriage. And the companies or the state government, for instance, granted health insurance pursuant to domestic partnerships. Well, you know what many of the companies are doing now in New York? Right. They're saying that unless you're married, you will lose this benefit. So same-sex couples that already have a domestic partnership, maybe they don't want to go through another ceremony or get married, but they'll lose that health insurance benefit if they don't. The companies are changing. So the interesting thing about this area of law is that it's family law, and then on top of it, it's same-sex law. And you have to check every nuance, because whatever you think is normal is not. You have to check estate planning. You have to check insurance provisions. You may have to provide additional insurance to count for tax impacts. You have to check tax law, because nothing is the same until there is full recognition of same-sex marriage. You have some protections that may be available by state law, other protections that may not be available by federal law, other protections that may not be available if you step out of state. And even within the state, even with same-sex marriage, you have to check the employer's laws, the health insurance laws, the pension laws. Everything applies differently, okay? Equitable distribution is not recognized. Federal law considers it a gift or sale of the asset. So, for those who practice matrimonial law, we all know that in a divorce, you transfer bank accounts, you try to equalize sometimes the assets, you transfer businesses, you transfer money in exchange for businesses, you transfer money in exchange for real estate, you transfer assets. There is no tax consequence. You transfer real estate, you transfer by deed. In a divorce of a heterosexual couple, there's no tax consequence when you transfer these assets. That's significant. That could be as much as 40 to 50% of the asset. But in a same-sex marriage, because of DOMA, that means that those transfers will be taxable events. The federal law will consider it a gift or sale of the asset. Gift taxes will be owed on any asset that were joint or transferred from one spouse to another. I spoke about pensions. A quadro is a qualified domestic relations order. Any time that transfer of retirement funds is done pursuant to a divorce, it's a special order that's drafted by pension evaluators or lawyers to permit the transfer of the retirement funds without a tax penalty. This is significant because many times you're not going to touch that pension until years later. So it's excellent that you can transfer the asset and not be taxed. So let's say you had $200,000 in a pension, right? If it's a heterosexual couple, you want to divide the pension. $100,000 goes to the other one, okay? With a same-sex couple, you cannot do it pursuant to the quadro, which permits the transfer tax-free and tells the pension administrator to transfer the pension. So that means that if the other spouse of a same-sex couple, lesbian couple, gay couple, wants that $100,000, half the pension, they're going to pay tax on it. The tax could be as much as 1/3 to 40%. So instead of getting $100,000, they may end up with $60,000. Okay? That's a big difference from a heterosexual couple. So you may have to think about you have to tax it. When you do a divorce, you identify assets and debts. I call it iced tea. Great drink, great singer, but critical in divorce. I stands for identify. C stands for classify. E stands for evaluate. And T stands for taxes. So first you identify all the assets and debts. Then you classify them as marital or separate property. Then you evaluate them. You put a price tag on each and every item. Okay? So real estate, you would get a real estate appraiser. Pensions, you get a pension appraiser. Businesses, you use forensic accountants. This is how you do family law. Family law affects each and every one of us, whether we practice as an attorney or whether we live it. So it's important to know. Then you must tax impact everything. So most times when you transfer these properties, right, you make a list of the assets. There's a business, there's a marital residence, there's a pension, okay? There may be deferred comp, there may be investment stocks and bonds. In a heterosexual marriage, you transfer these assets, there's no tax consequence, okay? The only taxes, the T at the end of iced tea is for taxes. So you have to tax impact each item. So maybe you have some real estate tax to pay if you're selling the home, or an IRA later, if you sell it, there'll be taxes. But now you have to do another step in the tax equation, because if it's a same-sex couple, there will be federal taxes owed. And you have to account for that difference. If you're trying to equalize the assets and the debts with a same-sex couple, then you must consider those extra taxes and either provide for it with life insurance or transfer additional assets. But that's something unique that you have to do. Okay? So let's talk about children of same-sex families. Okay? All right. It is also unclear whether a state will recognize the biological child of one spouse born during a marriage as a legal child of both same-sex spouses. Even if the home state of the couple does recognize both spouses as the legal parents of the child, other states may not. The non-biological parent may seek to obtain a second parent adoption. This adopting parent will thus take on the obligation to financially support the child, and the biological parent will give up the right to be the sole legal decision maker, and both parents will have standing or equal rights to seek custody and visitation. In some cases, it may be unwise to enter into marriage prior to completing an adoption. Some states and countries prohibit adoption by same-sex couples, but do permit adoptions by single parents. So, for instance, a same-sex couple is together. They would like to get married. But what they also have to consider, and that you as a lawyer have to advise them, is that if they plan on adopting children, they have to think where they plan to adopt children. There are many places where same-sex domestic partnerships or same-sex marriages will not be accepted. They cannot adopt together. So then it might behoove them to wait. For instance, in China, they will allow one parent to adopt. Some states in this country will not even allow a single parent to adopt because they think it's a gay person. They don't want it. You know, it's a discriminatory factor. Or they have a discrimination against single households. They have a discrimination against one person raising a child. They only want a married man and woman. Okay? So, these are the same battles that went through, and they're different battles, and actually there are different reasons. But there's the whole issue of whether people of different races can adopt children. I mean, in those arguments, there were cultural issues and whether that cultural upbringing of a child would be recognized. But like Obama said last month in Adoption Month, there are so many children that need loving families that regardless of race, religion, or sexual orientation, people should be able to adopt. You know, that's the presidential policy, but each state does not follow that, okay? So, in China, for instance, a same-sex couple that may want to get married, but if they also want to adopt a child from China, they should not get married because only a single parent can adopt. So many same-sex couples, one parent adopts, and then they do a second parent adoption later in this country. 15 states recognize same-sex second parent adoption. I do have that list. Let me see if I can find that. All right, we will get back to that.